Hi, this is the Session 14 lecture on contract law. A contract is a legally binding agreement between two or more people to do or not to do something. The source of contract law is case law. Unless you're selling goods, then the statutes kick in. The laws defining contract elements are similar from state to state, but there are slight variations. In the practice of dentistry, the applicable law will generally be stated in the contract. For example, look at the consulting agreement I handed out. You'll see it as California for choice of law. However, the associate agreement in the Assignment 3 folder indicates Minnesota as the choice of law in Clause 8.4. Contracts are a part of everybody's life. Some contracts you've probably entered into already, including leases, financial aid agreements, car purchase agreements, even ordering a meal, reserving a hotel room is a contract. They can be simple or very complex. They can be for goods or services, written or oral, implied or express. However, in order for a contract to be enforceable, various elements must be in place, and this is for every single enforceable contract. You must have competent parties. A contract cannot be enforced against a minor or a mentally incapacitated adult, for example. In other words, if you enter into an agreement with a minor and the minor fails to live up to her side of the bargain, there is nothing you can do. It's like the agreement never existed. A contract also must be for legal subject matter. For example, if you enter into an agreement with somebody to sell your expired pain medications on the street and you give them a supply of the drugs to sell, but they keep the payments, you will not be able to go into court and get your contract terms enforced. Again, because the subject matter of the contract was illegal, it's like the contract never existed. All right, all contracts need an offer. An offer is a communication of your intention to do something or to not do something. Offers can be oral or written. They can be for services or goods. For example, I will whiten your teeth is an offer, and I will sell you a teeth whitening kit is also an offer. All contracts must also have an acceptance of the offer. An acceptance is an expression of a willingness to be bound by the proposed agreement. Offers can be accepted in various ways. For example, by signing a contract. In your case, you will accept an offer of employment by signing the employment agreement. There can also be a verbal agreement. Not all contracts need to be written down to be enforceable, although it's always best to get contracts in writing. Contracts can be formed by performance. Acceptance can be performance. For example, if you offer to pay someone $200 to paint the walls of your office, the painting of the walls can be the acceptance of your offer. Contracts must also have consideration. Consideration is a legal concept. It's defined as something of value that's given in exchange for the performance or promise to perform or not to do something. Consideration is usually money. Consideration distinguishes contracting from gift-giving. Non-competes often fail because there has been nothing of value exchanged for the promise not to compete. This is less of an issue in Minnesota because Minnesota law defines the employee's new job as sufficient consideration for a non-compete agreement, so long as it is entered into at the commencement of the employment relationship. In Minnesota, it's not enough for the employer to give the employee notice about the non-compete agreement without actually presenting it prior to or in tandem with the job offer. However, if the non-compete is executed after employment is started, it is unenforceable unless something of value is given to the employee in exchange for agreement not to compete. For example, a promotion or some money. Breach of contract. The definition of a breach is when a party to a contract fails to fulfill her responsibilities as promised in the contract. For example, let's say you sign an associateship contract with a non-compete clause in it that prohibits you from practicing dentistry for a year within 30 miles of the St. Paul office where you have accepted your job. You end up hating this job and a buddy from dental school calls you up and asks you to work with him in a great location in downtown Minneapolis. So you quit and you go to work for your buddy. That's a contract breach. In most employment contracts, there will be a clause that states that a breach of part of the agreement is a breach of the entire agreement. In other words, by violating the non-compete clause, you have breached the entire agreement. In contract law, a remedy is the name for a legal solution available to non-breaching parties. Before any legal actions are taken, the non-breaching party, usually through an attorney, will send you a letter telling you to stop doing whatever it is that you're doing that is breaching the contract. These letters are often labeled cease and desist letters. The letter will, 1, threaten a lawsuit if you do not stop breaching the contract, and 2, demand that you meet whatever other requirements there are in the letter. Most jurisdictions don't require a cease and desist letter, so if you violate your non-compete by going to work for the competition, your original employer may just file a breach of contract lawsuit against you right off the bat. Okay, so here are some of the remedies for contract breach. Injunction. All right, so using the breach of non-compete scenario I just discussed, if your former employer sues you for the breach of the employment agreement, he is probably going to ask the court for an injunction. When an injunction is granted, the person who has breached the contract must stop engaging in the activity that is causing the breach. So the injunction in this case is going to prohibit you from working at the Minneapolis dental office with your buddy. This is kind of the equivalent of a court enforcing the non-compete in the contract. Sometimes a court will blue pencil the non-compete, which means that it will modify the non-compete to make it reasonable as far as scope and length of time. So if your non-compete in your original agreement was for 30 miles and 10 years, but that did not legitimately protect the St. Paul dentist's business interests, the court could change the area to whatever area and length of time were reasonable under the circumstances. So for example, 5 miles for 1 year. Another thing that a contract breach might bring to your former employee is monetary damages. If the court awards damages to your former employer, it is going to attempt to place the employer in a position he or she would have been in if the contract were performed. So the original employer will ask the court to award money damages. For example, the St. Paul dentist may argue that every patient you treated followed you to your new office, and that has cost him $200,000 to date and will result in future loss of fees in the amount of $500,000 until the end of the non-compete period. So what he is asking the court to do is have you pay him $700,000. The original employer will also ask for attorney fee reimbursement. In Minnesota, if the employer wins the breach of contract lawsuit against you, in addition to an injunction and money damages, the employer can recover what he paid his attorney to go after you. There's also something called liquidated damages. If there is a liquidated damages clause in the contract, the court will enforce that instead of trying to figure out how much profit has and will be lost by your former employer. Employers are becoming more and more likely to add liquidated damages clauses to non-compete agreements because it is difficult to prove the amount of money damages they are entitled to because of a breached non-compete. So you might consider a liquidated damages clause in an employment agreement as a fairly straightforward way to pay your way out of a non-compete agreement. It's up to you. When contemplating whether to breach a non-compete, consider the possibility that the old employer will most likely also sue your new employer for interfering with his business interests. Adding the new employer to the lawsuit increases the chances that the former employer will collect the maximum amount of damages. So if you get a new position that violates a non-compete, it's probably best to let your new employer know that it exists. Also worth contemplating is the likelihood that breach of an employment contract offense and indemnity is not covered in your professional liability insurance. You and your employer are probably going to have to pay for the defense of the lawsuit and any damages out of pocket. Specific performance is also a breach of contract remedy. A court may award specific performance for a contract breach when money will not put the non-breaching party back into the position she would have been in if the breach did not occur. Specific performance is not awarded in employment or other kinds of service contracts. It's usually awarded when you have contracted for something considered priceless. For example, if you contract to buy a Renoir for the office, but then the seller refuses to complete the sale, the court would order the seller to go through with the sale as set forth in the agreement. Rescission is another remedy. Rescission means the court attempts to unmake the contract and put the parties back to where they were before the contract resisted. This is the equivalent of canceling the contract. All the consideration must be returned, in other words, the money. Some states have contract rescission laws that allow a consumer 3 days to determine whether they want to go through with a sale. This is commonly referred to as a cooling off period, and this only relates to particular contracts. For example, in Minnesota, you have 3 days to decide if you really want a gym membership. If you decide you don't, and provided notice to the gym per your agreement with them, they have to give you your money back and cancel future obligations. This might also mean that you have to return your free water bottle, however. Contract termination. Contracts end for various reasons other than breach. So, for example, some contracts are intended for a limited time span, like a 1-year lease on dental equipment. Other contracts are project specific, so when the job is finished appropriately, the contract ends. On your slide, you will see a list of points to consider when you are contemplating a contract negotiation. I will give examples of these points from an employment negotiation I had about 10 years ago for a legal writing job. First, take care of your own interests. This can be a difficult rule to remember when reviewing a written contract. People write contracts to serve their own interests. They are not obligated to take your interests into consideration. Don't feel insulted or irritated by this, just accept it as the way that things are. You don't want to read things into the contract that make it more favorable to you, and you don't want to make assumptions that an ambiguous contract terms means what you want it to mean. So, for example, let's look at the consulting agreement I was presented with for my writing job. The original contract was heavily weighted towards the hiring corporation's interests. I was so insulted, I almost walked away from the negotiation. I'm glad I didn't, but it was really difficult to get my anger under control. So, look at paragraph 2C, and then down to 2C2. The non-compete, I felt, was way too broad. Look at the statement, in any way competitive with the business. Here it is, with the business, or demonstrably anticipated business of the company. That's very difficult to define. I do a lot of work for insurance companies. What if this prohibited me from getting people from insurance companies to lecture for this class? And then look at paragraph 4. In the termination, they can terminate my services without cause with a 30-day notice. Why would I even sign a year-long contract if they can terminate my services without cause with 30 days notice? Then in paragraph 5, in the relationship of the parties. During discussions, my position had been referred to as an employee without benefits. For the salary that was offered, that was fine because of self-employment and Social Security taxes. But if I was going to be a contractor, I needed to ask for more money, so this was a surprise to me. So what you want to do here is understand the entire contract before signing. Don't ignore something because it looks like legal mumbo-jumbo. Pay attention to the small print. Your failure to understand the contract terms will not excuse your failure to comply with those terms. Do not be afraid to ask for clarification from the person with whom you're contracting. Remember, in most every contracting situation in which you'll find yourself, you will be negotiating with a non-lawyer. The person you're negotiating with may not even know what the contract terms mean. Asking for clarification of a term in a contract can actually level the playing field when you are negotiating a contract with a person in a stronger negotiation position than yours. It can be embarrassing for a person to be unsure of what is in his or her contract. So, for example, I thought that this entire consulting agreement was too complex and barely applied to what I would be doing. I went to law school, but there's stuff in this contract that made no sense to me at all. For example, consider 2D. Let's find 2D. I'm going to talk about this right here. 2D. To the extent allowed by law, Section 2A and any license to company hereunder includes all rights of paternity, integrity, disclosure, and withdrawal, and any or the like that may be known as or referred to as moral rights, artists' rights, droit moral, or the like. Droit moral? For heaven's sakes, what does that mean? I mean, I looked it up. I know what it means now, but that's crazy. That doesn't apply to what I was doing here. So when I saw this, I was prepared to hire an employment attorney for myself to draft something that would better protect me. Now, you also want to know what you need to do to comply, point 3, with this contract. Make sure you're able to live up to your promises. If you sign a lease that requires a damage deposit, you want to know what you need to do to get the money back. If you sign an employment contract that requires you to take emergency call coverage at the direction of the employer, you have basically agreed to be on call 24/7 unless you get the parameters of the call coverage defined. All right, in this consulting agreement, I didn't include Exhibit A in the materials for today, but in Exhibit A, it includes the statement, the scope of services provided by consultant shall include the drafting of the newsletters and additional work as requested by the VP of Risk Management. To me, it seemed that I was on the hook to do whatever this VP asked me to do with no limits and no payment agreement for this additional work. So I knew I had to have this changed. Okay, point 4. Don't assume that your failure to perform will be excused. So don't agree to impossible terms and assume you can talk your employer or landlord, car dealership, whoever you're contracting with, out of enforcing it at a later time. You need to confront unattractive contract terms before you sign the contract. A lot of people sign contracts with non-compete clauses they don't intend to comply with, but then they expect the employer to see things from their side of the story when they resign and take a job with a competitor. So consider this scenario. You work part-time at a dental office. When you were hired, you signed a non-compete. You've been working in the office for 5 years and your relationship with the owner dentist has been excellent. Unfortunately, your spouse becomes disabled and you need to make some extra money to make ends meet. Luckily for you, there's a practice down the street that needs someone to take overflow patients. It's a perfect temporary solution, but it will violate the non-compete in your contract. However, don't assume the owner dentist is going to be okay with you picking up some work down the street. Here's a little personal experience that I had. About 10 years ago, a company I contracted with threatened to sue my business partner and me over a non-compete. After we all lawyered up, they finally dropped it. Basically, they had a weak argument. But I never thought that they would go after me, and I signed the non-compete without ever considering how it might affect my ability to get similar work in Minneapolis. If you can't live up to your end of the bargain, start discussions with the other party to find ways to work around a breach. Get creative, call a lawyer if necessary. Point 5, research the other party's finances and performance history. You want to know that the party with whom you're contracting can uphold their side of the bargain. You can do some research on the internet. If it's an employment situation, check the Board of Dentistry Licensing Action database and read some online reviews. If you're considering buying into the practice, your accountants and other advisors should help you determine whether the financials are good. Point number 6, negotiate when necessary. You should think of every contract as negotiable. Even contracts that don't seem negotiable might be. I've been told that the employment agreements at Park Dental are not negotiable, but perhaps that's something you should take into consideration when making your employment decisions. Leases may not appear to be negotiable, but you need to get into the tiny print and make sure you understand what you are agreeing to. If you are in a lease for practice space that does not allow the assignment of the lease, you're going to have trouble selling your practice because the buyer doesn't have a right to practice in that space. All right? There may be an opinion that a type of contract is not negotiable. For example, it took a while for small practice owners to figure out that EHR vendors were negotiating terms with large clients, but claimed that the terms were not negotiable for smaller clients. So Just because somebody says the terms are not negotiable doesn't mean that they are. So with the consulting agreement I've been talking about, I knew I couldn't sign the agreement I'd been given, but I really didn't want to give up what had been a pretty good gig for the past couple of years. So I had to find a way to get the terms turned more towards my favor. What I did is I worked my way through the contract and wrote down all of the things I couldn't agree to. Then I determined what I would accept as a minimum. Working through it convinced me that I really could walk away from this job if they refused to change the terms. Because the VP who was going to hire me didn't really know what anything meant in the contract when I asked him, I ended up talking to the lawyer who drafted it. She apologized and told me that she had downloaded the contract from a website because she really had no experience writing up consulting agreements, and it had been close to the holidays, so she hadn't put the time into it that she should have. I ended up talking through all of my issues with the VP. It was very uncomfortable, and I didn't like doing it. We threw out the contract, and we started over. The VP told me to draft an agreement, and the one that I drafted is also posted in today's folder. It was ultimately signed and revised over the years, but it worked, and I wrote it myself, and I liked the terms, and we all agreed to it. If you don't ask for something you want, you will never know if it was a possibility. But you have to remember, before you sign the contract is the time to negotiate. It is far more difficult to get unfavorable contract terms changed after the contract has been signed. All right, point number 7. Don't rely on what the other party says. Get it in writing. Even though contracts can be made by verbal agreement, contract terms can be difficult to prove if it is your word against the other party's word. If you absolutely can't get the contract in writing, keep very, very good notes. Keep letters, emails, checks, texts, or any other proof of the terms that were agreed to. Point number 8. Make contract revisions and amendments in writing. This is a variation on the prior point. If it comes to a lawsuit, a court is going to put a much greater value on what appears in the original contract than what one party claims was changed. Revising the contract and having the revised version signed by both parties can avoid conflict and keep a disagreement from turning into a lawsuit. Many contracts will have language like that found in Clause 8 at the end of Consulting Agreement 1 that prohibit any addendums from changing the terms of the agreement. Right here. This keeps people from attaching whatever they want to the contract and calling it an amendment. It makes sense. So make sure that you have the new contract language either drafted into a new version of the contract or get the amendments signed by all parties and find some way to discharge any statements about no amendments that appears in the contract. Over the years, I have been contacted by former legal issues students who decided to quit their jobs. In one case, a student wanted to quit her job, and her employer agreed to waive the notice period that was required in her employment contract. This seemed to be a good solution to her because it allowed the student to leave immediately, which actually was what both parties wanted anyway. However, the student failed to get the change to the notice provision in writing. 1 month later, she noticed that her paycheck for the week of work prior to the date she quit had not arrived. She called the practice, and the practice manager told her that she would not be getting paid because she had breached the notice provision of her contract. So the student called me, and she wanted to know if she should hire a lawyer. And unfortunately, I had to advise against it. Because there was nothing in writing, her chances of proving that she and the employer had negotiated a change in the employment agreement were not good. Even if she were able to get the former employer to agree to pay her, the lawyer fees would probably eat up most of what she felt she was owed. Point number 9, keep good records. This goes without saying, but I'm going to say it anyway. Both parties contracting will have affirmative duties pursuant to a contract. For example, if you pay someone for goods or services, get a receipt and keep it in a place where it can be easily accessed if the other party to the contract claims you didn't pay. If a service you have contracted for is not completed pursuant to the terms of the contract, get evidence of the breach. For example, take pictures, take notes, get a witness, etc. Presenting evidence of the breach to the other party can keep the situation from escalating. Finally, point 10, keep lines of communication open. Keep in touch with the people with whom you contract. Although this may not be an issue if you're working in a small office, regular communication can keep things on track. It can catch perceived breaches of contracts before things get out of hand. Thank you very much. That's the end of the lecture.